political engineering. That is the reason why General Parvez Musharraf brought it in. The initial chairman of NAB was General Amjad, I think, who was the first chairman who was rather naive in his views. And when he tried to pursue even-handed accountability and he went after some political bigwigs that General Musharraf wanted to cultivate, he was unceremoniously let go of, and then NAB continued along the path for which it was designed. Now, why do I say that the very basis and foundation of NAB is political engineering? Because quite clearly it was unconstitutional to begin with. Now, there's Article 12 of the Constitution, which says that nothing will be an offense. No person will be tried for a criminal offense if it was not a criminal offense at the time that he committed that act. It's basic. अगर उस वक्त वो जुर्म ही नहीं था तो उसके खिलाफ मुझे कोई सजा नहीं मिल सकती. दूसरा, the other part of Article 12 of the Constitution says that nobody shall be prescribed a greater punishment than what was prescribed at the time that he committed the offense. Now, the NAB ordinance does both, right? The NAB ordinance creates new offenses, like for example, willful bank default, etc., was made a NAB offense, although it was never an offense previously. And it also enhanced punishments for offenses such as corruption, etc. They existed, there were laws that punished them, but the NAB ordinance enhanced those penalties. And it did so with retrospective effect. So it was in clear violation of the Constitution, and therefore people were, and to this date, Mir Shakil Rahman, for example, spent nearly a year in jail for an offense that was alleged to have been committed about 15 years before the NAB ordinance was promulgated. He was being tried under NAB laws for an offense that was alleged to have been committed when the NAB ordinance didn't exist. The other unconstitutional aspect of the NAB ordinance was that it allowed the NAB chairman an arbitrary discretion to decide what cases would be prosecuted under the NAB regime and what cases would be left to the ordinary criminal laws. So you had a lot of these cases where some people, for identical offenses, for seemingly minor offenses also, they had NAB proceedings against them, they were denied their ordinary statutory rights of bail, they were subjected to harsher punishments, and others were for no cogent reason left to the ordinary law. This kind of discretion, allowing an individual to choose what set of laws becomes operational against whom. The Supreme Court of Pakistan has struck down laws like these, from 1957, there was a Waris Mia case. Quite recently, 2016, 2017, they did it with FIA offenses, banking offenses in the Salman Mujahid case. But the NAB ordinance somehow escaped that judicial scrutiny. It was challenged in Asfanyar Wali's case, and the reasoning in Asfanyar Wali's case is absolutely astonishing. There are all these constitutional challenges are ignored, and the court holds, and I want to quote this because I don't want to get a Supreme Court's finding wrong. It says, while upholding the constitutional validity of the NAB ordinance, the court observes that the de facto and de jure status of the present regime, this is the Musharraf regime, was recognized to create a corruption-free atmosphere. And this court took judicial notice of the fact that the people of Pakistan generally welcomed the army takeover. And this was kept in mind while examining the validity of the impugned ordinance. So basically the NAB ordinance, the constitutionality of the NAB ordinance was upheld because the Supreme Court in Asfanyar Wali's case said that the people of Pakistan wanted an army takeover, and that's why we are holding the NAB ordinance despite its constitutional defects. We are upholding its constitutionality. Now, I do think the time has come, not just for the legislature, but also for the judiciary to re-examine the vires of the NAB ordinance. Now, there is another aspect of Asfandyar Wali's case which bears mention. Now, you know, the other corruption, offences of corruption, etc., that are under the Pakistan Penal Code, they're equally applicable to the military. In fact, all the various armed forces laws, they specifically incorporate the offences of the Pakistan Penal Code. However, the NAB ordinance conveniently, and this is why I say political engineering, it excludes the military from the purview of the NAB. Now in the Asfandyar, however, it did not, in its original phrasing, exclude judges from the purview of NAB. But when in Asfandyar Wali's case, the Supreme Court was deciding the constitutionality of the NAB ordinance, the Supreme Court said, well, judges should also, we are all right, and it was challenged on the basis of discrimination. Why are the armed forces being excluded? So the Honorable Supreme Court said, well, it's all right for the armed forces to be excluded, that's all right, it's not discrimination. But also we feel that judges should also be excluded because we have our own accountability mechanism, and therefore it is not discriminatory. So it is, I think, examined because
to what has happened and how it has affected social.
As you know, they cite figures about how much recovery they have done and all of that. But there is equally, I'm sorry, I just got, I didn't see this note earlier, I'm sorry. I'll just wrap up. But equally, there is a paralysis amongst the administration because of this perpetual hanging sword of the NAB. You see, selective accountability is sometimes worse than no accountability because it breeds this impression that it is not my misdeeds for which I am being punished, but it is for my closeness to a political party or due to my political views that I am being punished. So there is no lesson learned for the people involved. They say, okay, next time I'll improve my political ideology and my political stances. It's not my corruption for which I'm facing charges. Now, I'd like to end with this wonderful quote because I've criticized one judgment of the Honorable Supreme Court. I should actually laud another judgment, and that is the one in Saad Rafiq's case. Justice Maqbool Bakar in that starts with a quote from John Stuart Mill whilst examining the historical role of NAB in this political engineering exercise. He quotes Mill, and Mill says, "A state which dwarfs its men in order that they may be more docile instruments in its hands, even for beneficial purposes, will soon find that with small men no great thing can ever be accomplished." Thank you.